well. We start with the latest coming in. SEBI has filed a rejoinder in the Supreme Court in the plea seeking extension of time for investigating into the Adani-Hindenburg case. Now, news coming in on how the investigation done earlier by SEBI pertains to the issuance of the GDRs by 51 Indian listed companies, in respect to which investigation was conducted. However, no listed company of Adani was part of the aforesaid 51 companies. This is a submission that's been made as far as the SEBI rejoinder in the Supreme Court is concerned, as the top court once again will be taking up the case today. It also says, in the context of investigation into the minimum public shareholding norms, the MPS, SEBI has already approached 11 overseas regulators under the multilateral memorandum of understanding with International Organization of Securities Commissions. Okay, so those are details that Times Now is picking up with regards to the SEBI rejoinder in the top court. As far as today's hearing is concerned, an important update, Bhavtosh, if you could just help it break down for our viewers.
Well, SEBI has filed a rejoinder in the SC, and they have in fact sought more time to investigate this entire issue. And remember, in the previous hearing that happened last week, SEBI wanted a 6 months extension, and they have said that the entire Hindenburg issue, in the Hindenburg, the short seller had said there were 11 suspicious transactions, and SEBI was in fact going through them, and post that they sought 6 months of extension of time. Now they have said that the rejoinder in which they have filed, they have said that 11 companies were under the scanner, and the further they have said that as far as by 51 listed companies, and in which investigation was conducted. However, no listed company of Adani Group was part of the aforesaid 51 companies. Allegations that Stock Exchange Board of India, that is SEBI, is investigating Adani since 2016 is baseless. Now, that's very important. In the rejoinder that has been filed, SEBI has said that allegation that has been leveled, that it has been investigating Adani since 2016, is completely baseless. There were several reports, Christine, which said that because Adani is under investigation since 2016, government had completely buried this issue. The market watchdog has completely buried this issue, and that could probably lead to this collapse in the market, and also the share prices that completely went downward stream after the Hindenburg report. But SEBI in its rejoinder has now said that it is completely baseless, that it was investigating the Adani stock prices since 2016. That is a rejoinder that has been filed by by the SEBI. The matter will be coming up post-lunch at around 2 p.m.
Okay, it's a crucial hearing that's going to take place today. Let me quickly go across to Siddharth as well, since this is a big claim as part of the rejoinder in the top court. Allegations of probe since 2016, SEBI says, are baseless. If you could get us more details, Siddharth.
Yes, Christine. So 3 or 4 very important points highlighted by SEBI in its fairly short rejoinder. The first, of course, is a categorical denial over the claim being made by the petitioners that SEBI has been investigating or looking into the Adani Group since 2016. And here's the response of SEBI. It says, hence, the allegation that Securities and Exchange Board is investigating Adani since 2016 is factually baseless. I therefore say and submit that reliance sought to be placed on the investigation pertaining to the GDRs is wholly misplaced. Then, of course, it goes into the report that has been the interim report that's been submitted by the expert committee in this particular matter, where it says that the expert committee constituted by this honorable court, covering the steps taken, responses received, and the current status of information gathering under MMOU of IOSCO. I say and submit that in respect of the investigation relating to 12 transactions referred to in the Hindenburg report. Now, this is pertaining to the Adani Group. Prima facie, it is noted that these transactions are highly complex and have many sub-transactions across numerous jurisdictions, and therefore a rigorous investigation of these transactions would require collation of data or information from various sources, including bank statements from multiple domestic as well as international banks, financial statements of onshore and offshore entities involved in the transactions, and contracts and agreements, if any, entered between entities, along with other supporting documents. And therefore, analysis would have to be conducted on documents received from various sources before conclusive findings can be arrived at all. So the transactions under scrutiny will have to, of course, require a far greater and a deeper examination, and that is something that is going to take time on the part of the SEBI. And therefore it says SEBI is meant to ensure carriage of justice, keeping in mind interest of investors and securities market, since any incorrect or premature conclusion of the case arrived at without full facts of material on record would not be able to serve the ends of justice and hence would be legally untenable. So therefore, these are some of the reasons that